Proving retaliation isn't easy. Most employers don't come out and say they retaliated against you because you engaged in protected behavior. Instead, you will need to show the retaliation through evidence that you may have already collected or that could be gathered through the discovery process. I'm attorney Laura Schultes with RSH Legal. If you feel that you are being retaliated against at your job in Iowa, you may be feeling angry, humiliated, or hurt. Retaliation can come in many forms in the workplace, and it's important to know how Iowa law defines it. It is also important to know that not all retaliation is illegal. Retaliation is only against the law if it is motivated by an unlawful reason. There is no general law in Iowa that prohibits retaliation in the workplace. For example, if you butt heads with your supervisor over his or her methods of running the business, and as a result, your supervisor retaliates by assigning you to work a shift that you don't like, you probably do not have a retaliation case. In order for you to be legally protected from retaliation, the retaliation must take place in response to you, the employee, having participated in an activity that the law considers protected from retaliation. General disagreements with your boss are not protected activity. In fact, Iowa law has a fairly narrow view of what protected activity is. Some examples are making a workers' compensation claim, reporting illegal activity, fulfilling mandatory reporter obligations, making a complaint to OSHA or another workplace safety agency, speaking out against harassment or discrimination that targets someone because of race, sex, age, disability, or a similar classification, requesting disability accommodations or taking approved FMLA leave. If you have engaged in one or more of these kinds of activities, and your employer has retaliated against you, you may have a case. There are many ways that an employer could retaliate against you. For example, retaliation could include one or more of the following types of activities: transferring you to a less desirable department or shift, demoting you, withholding a raise or a promotion, giving you an unfair and negative performance evaluation, reducing your pay or your benefits, verbally abusing you, or firing you. If you suspect that you are being retaliated against because you participated in legally protected activity, you are not helpless. The first thing that you should do is report the suspected retaliation to a human resources representative. If you voice your concerns and the retaliation is not addressed, or it continues after you report it, you should speak with an experienced Iowa employment law attorney. An attorney can review your claim and tell you whether you have a case. If you do, a skilled employment lawyer can advise you what the legal process is for addressing the retaliation that you have experienced. Proving retaliation isn't easy. Most employers don't come out and say they retaliated against you because you engaged in protected behavior. Instead, you will need to show the retaliation through evidence that you may have already collected or that could be gathered through the discovery process. If you're still employed, it may be helpful for you to document meetings and events that you are called into with your supervisor or an HR representative. If these meetings turn to talk about issues regarding your work performance, it's okay to take notes during the meeting or right after. Write down all of the details that you can remember. You can also keep important documents and records. It is crucial that you keep any documents that are related to your employment, as these kinds of documents can provide important information to an attorney early in the case and help negotiate your case to a fair settlement or investigate what claims you may be able to allege. Some examples of the important documents that you might keep copies of include things like a performance improvement plan or a PIP, termination letter, the employee evaluations or performance reviews that occurred both before and after the retaliation, emails or notes from your supervisor that show improper conduct on their part, documents that indicate notice of a demotion or a reduction of pay or benefits. If you believe that you are being retaliated against, it is important that you contact an experienced Iowa employment law attorney as soon as possible. RSH Legal offers a free, no-obligation case evaluation. To schedule yours, call 1-800-433-0283 today.